Good morning, everyone. Join us once again for our weekly broadcast. We have arrived at 10 a.m. on Thursday once again, now in the month of November, as time marches on. So good morning once again to John Corey, our resident co-host. Good morning, John. How are you?
I'm good. Looking forward to today's topic.
Absolutely, and delighted to be joined by David Willbe. So good morning, David. Good to have you here.
Morning, David. Morning, John.
Fantastic. So for anyone who just is maybe tuning in for the first time, this is round about a 30-minute weekly broadcast we do at 10 a.m. on a Thursday. And the idea behind these broadcasts started actually during COVID back in March 2020. We've kept them going because the feedback we received from property developers, from investors, from experienced people in the market, right through to sort of newbies in property. We got a lot of great feedback, John, from people who just found them very informative, educational, and a lot of people who can't tune in on the day watch our recording on YouTube. So the feedback has been very, very positive, John.
Mm-hmm. Oh yeah, and this is also an opportunity to go cover a number of topics and create a back catalog that people can search and review and catch up on. So it works really well.
So we normally do a brief market overview. We usually have a guest or a special topic, and then we also update on some things that are happening within the world of Leo crowdfunding. We're an equity property crowdfunding platform, and therefore we do have some content that's relevant to our platform. But in the main, it's sort of general property market relevant information. So I'm David Johnson, CEO of Leo Crowdfunding, and John, who you've heard from, runs Property Fortress and does a lot of consultancy work and around the compliance, deal structuring in the world of property investment. So let's get straight into today and our market update, where we like to start, just so that we're making sure that we're aware of what's happening out there. John, I've chosen for this week Knight Frank's October UK residential property market update. The big headline out of their report was that they are forecasting a 10% forecasted cumulative fall in house prices during 23 and 24. Obviously, it's a crystal ball. It's a bit of sort of gazing into the future and who knows, but it's interesting that Knight Frank, who obviously know a thing or two about the property market, have put a figure on where they think the market's headed over the next sort of 12, 24 months.
Well, it should be remembered they don't make any money by their predictions. So I wouldn't put too much weight on any predictions, especially off into 2024. If we think about it, we didn't know about COVID 2 years in advance. We didn't know about the Ukraine situation 2 years in advance. But what is interesting is I think of this as if the property market was to crash, it'd be like a store putting a sign up saying everything's on sale, 10, 20% off. And normally in a retail environment, that causes the line of people who want to buy a bargain. And in the property market, it's like, oh, I got to wait till prices go back up. I don't want to buy on sale. So it's a very funny sort of phenomena that happens, and there's reasons. But this benefits landlords. Actually, tenants tend to stay longer when prices go down.
Yeah, and that's an interesting point which they actually draw attention to in the report. I think what I like about these, John, is that while we often, I was going to say poke fun, perhaps not the right term, but we often highlight the inconsistencies of our tabloid press and how they can generate fear and generate uncertainty just through a headline that very often is based on nothing in reality. These reports, they at least have data that underpin why they have an opinion. So, for instance, new buyer inquiries fell for a 5th month in a row. That's hard data. You can obviously disagree how to interpret the data, but at least the data is there, that there's a clear data point that says that actually the market's heading a certain direction. I think that's useful.
Well, you're implying that there's cause and effect. And I would say it rained in Yorkshire, and therefore that's hard data, but does it have relevance? And it does matter to possibly also different sectors, that if you're a sales agent and inquiries have dropped, that's probably very germane to what you do. if you're a landlord holding for 20 years, like, why do I care?
Mhm. Yeah, and as you indicated, the letting market is obviously going to be a strong market. So if anyone wants to read that report, the link is on the screen. What I like about the Knight Frank reports are they're nice and succinct, usually just 2 pages of summary, which I think is useful just to read. So David, I don't know, I'll just bring you in here. John,
One second before David, I think there is something to be said for Knight Frank and a few other of these companies that they've been doing it for a while, so they tend to be able to sort of compare between their past predictions or other trends, and you can see relative change or relative importance on what they're tracking. So even if it doesn't affect you, it affects maybe the people you're dealing with in the marketplace, people you're buying from, the people you're selling to, people you're renting to or renting from. So knowing how other people think is also useful.
Yeah, no, that's a very, very good point. And I just thought to bring David in there briefly. So I don't know, David, if Knight Frank for the monthly report is on your monthly reading list or not, or do you sort of stay on top of these sort of things? Just any input?
Yeah, absolutely. I mean, there's a number of things that we try and stay on top of, and like you say, you can't put your bet too firmly on any prediction looking too far forward, but it's good to get a temperature of the market. A lot of these things move in herds, right? And if everybody's looking in the crystal ball and seeing doom, then you can behave accordingly. Even if that doom never comes to pass, people will act in a certain way if that's what they think is coming. So yeah, we try and stay on top of it. Law firms are generally pretty conservative organizations, and we don't do anything too dramatic on the basis of any of these reports, but we do keep abreast of them just to make sure we know, the temperature, I think, is the word I'd use.
Yeah. No, I love the 2 words crystal ball you used. And I love crystal balls, and John does not like crystal balls. So if I'd known you were going to say that, David, I would have had a nice picture of a crystal ball, because I often put John on the spot with a big slide with a crystal ball and say, right, John, what's going to happen? And he doesn't like it. But no, I take your point very well. So thank you for that. Okay, that's the market update. One slide before we get straight into our discussion today. For anyone around the London area or in a suitable train journey from London, next Wednesday, 9th of November. I suppose it leads on from what we just talked about, the uncertainty in the market and trying to interpret data. We have an investment strategy in uncertain times event. This is a joint event with Leo Crowdfunding and PLMD, a developer based in Stratford. We're doing the event in the offices there. We ran one a few months ago with about 50 attendees, which was really, really well attended, and a really good night. A lot of good networking as well as discussions. So myself, AJ Kapoor, the MD of PLMD, and Dal Ray, our investor portfolio manager here at Leo Crowdfunding, will be doing sort of short 10-minute slots on different topics around this investment strategy in uncertain times. And then the majority of the night is to do with networking. So there'll be refreshments supplied. It's going to be a really good night. So you can see the Eventbrite ticket there. You can get your ticket by going on there and booking. So it's a 7 o'clock start, registration, refreshments, and then we get into the event. So feel free to join us. Look forward to having you, and we'll give a wee update then next Thursday as to how that went, perhaps with a few photographs. So let's get straight into today. Looking forward to today. We like to deep dive, David, into sort of relevant topics, but from from the professional side and the expertise side. Sometimes a little knowledge is dangerous, they often say sometimes in business. So talking about things like legal documents and property and things like that, people can have a little bit of knowledge, but really we need to have the experts on to really give us the lowdown. So I think first of all, David, you want to give us a bit of your background, obviously how you've ended up to where you are now, a bit about Lewis Silkin, and then we'll get into the discussion.
Yeah, absolutely. So I've been, I should say, I'm a corporate lawyer primarily. So I work with businesses that are fundraising in various ways, and I've been doing that for, close to 20 years now. And that's my interest, and that's how I come to these kinds of setups. So everything from venture capital, angel investment, private equity, that sort of old traditional ways of doing things. And then obviously, as we've evolved, new ways of fundraising, including crowdfunding, of course. Those are things that I try and make sure that I can work with. So, however it is that my clients are looking to raise money, I have hopefully something relevant to say and can help them make sure they do it properly. So that's my background. I work with companies at all stages, from very early to very late, and they are generally raising money to do something interesting. Obviously, with the people that I meet through Leo, that's in the property sphere, but it's not necessarily that. It's pretty much anything that you could raise money to go out and do. I've probably helped someone raise for. Lewis Silkin, the broader firm, we do of course have other services than just me. I have lots of colleagues around the place, including a real estate team that regularly does work with developers and more pure property work. That's not really my field, but I know a little bit about it, obviously, from the deals that I've been doing. But yeah, my main focus is on the fundraising and the sort of shareholder arrangement side.
Excellent. Thank you very much indeed. So if anyone has got any questions or any points they want to make, either a question for David or a point on something that's said, of course, put your comments into the Q&A box. Don't use the chat box, use the Q&A box, please. And we'll be able to deal with those as they come in. And if there's any broader comments with time at the end, then we can add those comments into the discussion about anything general. So the topic that David we gave you today was legal documents and property, and that's quite a wide, and I've listed out sort of probably 6 areas. 1 to 4 we don't really want to get into today, but obviously they're obviously relevant in terms of someone involved in property. 5 and 6 is where I want to really focus the discussion around shareholder agreements. But have you any just introductory comments about just agreements in general, contracts in general, that you think is relevant to all 6 of these?
Yeah, I do. I mean, certainly, 1 to 4 is one of those things that there are sort of standard forms out there in the market for those documents. And just going back to something that you said earlier, David, about a little knowledge being a dangerous thing. Standard forms are great, and they make everybody's life easier. And that must be a good thing. I think the thing I would say, and obviously I'm biased here, but the thing I would say is it doesn't replace the need for advice. And the problem that we're seeing again across a whole run of clients, not just in property, but it does exist in property, is people see a standard form and assume that they can just kind of go ahead and use it without kind of tailoring it to their circumstances and the transaction that they're doing. So, that would be my sort of general word of warning, particularly on 1 to 4. Yes, absolutely, you can go out and find these things. Yes, they exist. Yes, they're very good documents. But there is still some value, I hope, in speaking to somebody in my profession and saying, look, this is the exact thing that I'm doing. How are we going to change that document just to make it exactly right for me?
Well, I think, David, to play up on that is, and I've personally reviewed a few of these, people do tailor it to their situation, and they think they can do their own tailoring by mixing and matching. And I is not I'm not a lawyer, and I'm like, but in this one paragraph, your first sentence contradicts your 4th sentence. And did you cut and paste this? And, well, yeah, I did get a few forms and put it together. And it's like, well, this no longer works as a contract. It's in conflict with itself. They had one where it said shareholder agreement, and then it talked about partners, and then it talked about something else. And I went around the table and I said to, based on this agreement, you're never going to get paid because it says you don't. And did you know that? And then on you, well, you're actually going to have no control because you can't use email and you don't want to travel. So whoever made this document up is completely off base.
Yeah, and I look, I'm biased, as I said before, because the shareholder arrangements is where I really get interested. That's what keeps me doing this. But my view is, a standard form shareholders agreement or something you just pulled off the shelf, that doesn't exist, because more than in any other kind of context, a shareholders agreement is always about the people. So you just mentioned, somebody who doesn't want to travel and doesn't want to show up in person for meetings, but you haven't put email in the contract. Classic mistake that people make. So yeah, I think for always with a shareholders agreement, you're going to have multiple people, multiple sort of different circumstances that you need to reflect, and you just need to make sure you're doing the right thing for your circumstance.
Okay. So thinking about shareholder agreements then, John, do you want to take a minute and just highlight the importance of shareholder agreements within the world of crowdfunding?
Okay.
And
Yeah.
you also got shareholders in general as a concept, but it's very specific when it comes to the world of crowdfunding.
Well, to just almost slightly broaden the question, crowdfunding can have loans or they can have equity, as in shares. And there's crowdfunding for loan, and that's not what we're talking about here. We're talking about crowdfunding where you're raising equity and therefore you're selling shares in an SPV for a project. And therefore you want a shareholder agreement that's relevant for that project and relevant for those shareholders. And I know I'll ask David, so I'll say it right now. You can also have the articles, which is how the company was set up, and then you can have the actual shareholder agreement for that tranche of shares or that round of funding, because you might have different shareholders that have different agendas, and there's the founders, there's the people who come in maybe later. So in the world of Leo crowdfunding and the deals I've actually participated in as a shareholder, the crowd is a special group of shareholders that have come along to put up some money. We want to be first in line, so to speak, among the other shareholders. So there's different classes. So Dave, if you could sort of take that mishmash that I just sort of highlighted and address this articles versus shareholders and prioritization and things like that.
Yeah.
And by the way, David, I do, of the shareholder agreements I've read on the Leo crowdfunding site, and I've read quite a few, the ones you have drafted, I tend to like the best when it comes to how they read, whether I understand them and things like that. So, well done to you.
No, I appreciate that. Thanks, John. It's it is a balance between making sure that they work exactly as intended and making sure that people can understand them. And those two things are not always aligned. So I appreciate you saying that. I mean, the Articles of Association, let's start there. That's the constitution of the company. And there are certain things that need to be in there. And there are two reasons. So one is if you need your shares to behave in a certain way and you need the law to respect that, then that needs to go in the Articles of Association. So again, to look at the Leo model and some of the companies that we've worked with, they have the idea of redeeming investor shares right at the end of the I don't know what you'd call it, the life cycle of the investment, let's say, when investors have received their whopping great returns. You need those shares to go away because it's all done. They've got what they came for, and in order to make sure that the law basically allows you to do that, you need to write into the articles that one of the characteristics of these shares is that they're redeemable. So, that is just a straightforward, if you put that in the shareholders agreement, it just wouldn't work.
Okay.
So that's one reason why you might do it. So if it's a characteristic of a share, I know we don't do this on Leo crowdfunding, but just for people's general interest, in other circumstances, it might be a fixed dividend on a share, for example. Again, if you want that to be a characteristic of the share, you want it, voting rights, you want dividend rights, you want an entitlement to capital if things are wound up, a liquidation preference, as they call it. Those are characteristics of a share, and you need to put those in the articles if you want the law to acknowledge them. The other thing is, and this is where it gets a bit more subtle, the distinction between what do I want to happen if somebody goes against this thing that I've said? And the very basic division is, if I put something in the articles that says it must be done this way, and then it isn't, that may be void. If I put it in a shareholders agreement and I say this must be done this way, and it isn't, it still happened, but I can sue for my damage. And I spend quite a lot of time thinking about that, and trying to make sure that I get the right document in the right place, the right obligation. I apologize, in the right document, because ultimately, that's my job, is to make sure that everyone has the right remedy in the event that it all goes wrong. And of course, the vast majority of the deals that any lawyer works on just goes in the drawer, and nobody ever does it. But if it does all break down, we want people to have the right remedies, and the remedies that people expect. So that's the division that I would make between the articles and the shareholders agreement. I hope that kind of makes sense.
Oh, that's spot on. And now I understand.
Yeah.
So if there's a financial, oh, sorry, David.
No, go ahead. You go ahead.
So the reason why, for example, in my shareholders agreements on the platform, you would see the division of proceeds in various different situations in the shareholders agreement, just to give an example, is because we, the deal for and I'm acting for the company, by the way, but nevertheless, you have to deal fairly with people. The company, in the event that those proceeds are not divvied up correctly, the investor should have the remedy to come back and say, well, no, actually, that's not, you haven't given me the right amount of money. And they need to be able to sue for it. And the sort of remedy of putting it in the articles and saying, oh, well, then that doesn't count, it doesn't quite work, because you would then need to kind of unwind that transaction and go after other shareholders and claw back money from them, and that's not quite the right remedy. So that's an example of that division.
Good.
Okay, no, great. So narrowing that down just a little bit more, within the world of property crowdfunding, the shareholders are passive shareholders in the SPV, and I tend to think, while obviously all the clauses are important, the redemption of the shares and the circumstances that happens, and also the distribution of the profits are probably the two key clauses. Would that be fair to say, David, in terms of getting the language right, making sure that first of all, the fundraiser, and again, I like to point out, you operate on behalf of the fundraiser. The fundraiser pays your legal bill to produce the document, but you do produce an agreement, which means there's two parties to the agreement. So you've got like that sort of threading a needle a little bit, that you're paid by one side, but you must produce something that both sides are acceptable with.
Right, and particularly in a kind of one-to-many situation, like on a crowdfunding platform, because the individual investors generally aren't going to have an opportunity to sort of say, it's not like working with a venture capital house where I'm going to go backwards and forwards with their lawyers on the investment documents, 4 or 5 times, right? That isn't going to happen. It's going to be the difference between an investor puts the money in and they don't, because what is reflected in that agreement should be reflected in the offer document and the proposition. And, ultimately it's either an attractive investment proposition or it isn't, right? And if what we say in there is, well, the funders can take their profits first and there may or may not be anything left for you shareholders, then that's not an attractive investment proposition. So we need to make sure that it works properly. And, in my view, it's in the best interests of the fundraiser to make sure that there's an agreement which deals fairly with their investors, because the alternative is the investor just doesn't invest, right?
Yeah, that's a good point. So John, I'm just trying to think on the hoof here of any tangible examples. Don't necessarily have to mention the fundraiser per se, but tangible examples where we've worked with David on some problem clauses and how we went back and forward to get the right ones. Unless, David, you can think of any at the top of your head as well.
I mean, a classic one is a development with multiple properties, and we have the extremes of all the properties get sold. They get sold in a timely fashion. The money comes in, the shareholders are bought out or somehow redeemed, and they get a dividend or just a lump sum. The other end of it is none of the properties get sold. It gets refinanced. How do we determine the value? Therefore, how do we decide what the profit is? And then there's the messiest one, which is similar to that, which is the hybrid. A little were sold and a little were not sold. And maybe you get a benchmark from the sale for what the values are, but it's this idea that we didn't have a clean arm's length transaction to establish value and make it all cash. So there needs to be wording, and David's done this a few times, where there's this progressive, almost like a waterfall, where, well, there'll be some sold and we might refinance, and the people running the project have the right to try to sell for a certain time, and then they have the right to refinance, and then they will attempt to redeem the shares at this value if there's sufficient money, and if there isn't, then the project will continue. And thinking all that through is important. And one of the things I do like about crowdfunding is it's not a debate, and it's not a sort of major negotiation. The shareholders pretty much are being asked, do you like this? Yes or no, accept it or not. And the reason I like a cleanly drafted document, and this is where I appreciate David's work, is, okay, what am I signing up for? And do I want to be in or do I want to be out? And if I want to be in, great, I sign it. And if I don't, I don't. But at least that way I know everybody's signing the same thing. No one else is negotiating a better deal. No one else is actually changing the deal so that it's not what I thought it was. Everybody's agreeing to the same thing. We all have the same remedy if we don't like where we stand.
Mm-hmm. I liken it sometimes, David, to in the military we have what's called a combat estimate, where you would look at a potential battle scenario or a planned attack, and you would do your courses of action. So you would kind of think, well, if the enemy do this, so what? I.e., what comes out of that? In some ways, I look at shareholder agreements a little bit like that, where it's like, okay, there's currently 3 partners in this development company. What happens if they fall out? What happens if one of them gets a serious illness and they were the key person with the expertise in the partnership? How does that affect the shareholders? John's alluded to what happens if they don't sell. What happens if there's a fire sale? So you as a lawyer have got a lot of trying to think outside the scenarios that may happen. We hope they never do, but the shareholder agreement, in my mind, should cover every eventuality that could potentially happen, and then lay out how that scenario is dealt with. Is that a fair summary?
Yeah, I mean, you're never going to get 100% coverage, but yeah, exactly right. I mean, as much as you possibly can, and JV agreements, just to kind of move on slightly, for a corporate JV, so in other words, 2 or 3 or 4 shareholders in the vehicle that is doing the development or whatever else, those are a different kind of shareholder agreement. So where a crowdfunding agreement is effectively one-to-many on a shareholders agreement level, and it's take it or leave it, a corporate JV shareholders agreement will be heavily negotiated between a very small group of shareholders. And the absolute key thing in that document is exactly what you're saying, which is, in a world where one party just stops contributing, what do we do? Or in a world where you reach, and I'm sure this is a term you're both familiar with, deadlock. So if you reach deadlock in your JV, because every party in that JV is going to have some rights to block certain actions going ahead. So classic, 2-party JV, certain things require both parties to agree. If one feels strongly that we should, and the other feels strongly that we shouldn't, and the business is deadlocked, what happens? And we spend, the vast majority of our time when we're engaged on JVs doing this basically disaster scenario planning, and how do you get out of it? And you can tell that we spend a lot of time thinking about it because it has all the coolest names in the legal profession. You get clauses called things like Texas shootout and stuff like that. You can tell we've spent too long thinking about it when we're coming up with names for stuff.
Well, what I particularly like about it is a slightly different scenario, that maybe it was a 2-person JV or a 2-person agreement, and they're working collaboratively, they're perfectly fine, and they die a horrible death in some accident on the site. And then the estate of A and the estate of B are effectively in dispute about how we're going to dissolve this, and they go to the judge, and the judge says, well, show me the signed documents and I'll start there. And if it isn't clear to the judge how to settle this, then we got a problem. So I'd like it to be clear enough that if the people who are the principals and knew what it should say can't speak, then you have something that at least encapsulates what they did agree. And a point that I know David and I've talked about is it's great to talk. It's great to trade emails. You got to get it written down in a final agreement so that there isn't any ambiguity about, well, didn't you say this on such a date in email 56? It was like, well, I don't know. Can we just get it down to something reasonable so the judge can just look at the contract?
Mhm.
Yeah, no, that's a fair point. And the JV agreement there, David at the end is sort of thinking about where a developer maybe brings another developer on board a project, and maybe very often they're kind of in a desperate situation. They need maybe expertise, to fulfill the requirements of a crowdfunding raise, or they, need resources potentially, and that other person may come in not as a passive investor, but come in as a JV partner. But very often where one party sort of needs this to happen is when, the shortcuts happen, and unless that agreement is rock solid, the initial originator of the deal can find themselves in a very sticky situation with a JV partner.
Yeah, it is. Yeah, in negotiation, there's always leverage, right? And somebody who is in a very strong position and has has all the leverage, and they know it, and can take liberties with those sorts of things. I think, yeah, getting an agreement down, to your point, John, is, I try not to speak too much about case law whenever I'm allowed to speak, but there is some really terrifying stuff out there at the moment about judges putting together, this is what I think the agreement looks like, exactly by going back and looking at email 56. And actually, one of the great things about having an agreement written down and having, the four walls of the agreement, you will always have a clause in there that says, and this is it. None of those emails count. None of those conversations count. None of any of that. It is just what's in here. And I think, particularly in those high leverage situations that you're talking about, David, you may have to do a bad deal, because you've ended up in a bad position, but at least understand what that deal is and get it, within the four walls, so that everybody's clear on what can happen and what can't happen, and at least then you can behave accordingly.
A really important point there is, and I've said this to some individuals, I don't care what the equity offer document on the legal crowdfunding said, the site said, if it isn't in the shareholder agreement, it doesn't count. So in a sense, those four walls are the shareholder agreement. And if you think you're going to get the following because in a webinar or in a forum discussion or on an equity offer document, something was said, make sure it's in the shareholder agreement if you want to count on it. Otherwise, forget it. And it doesn't matter that there's still an equity offer document that you can look up. It's like, no, the four walls have been erected in the shareholder agreement and also, I guess, in the articles, so that we now have a boundary that says that was all just water under the bridge.
Yeah, totally agree.
Teasing that out slightly though, David, where we add the equity offer document as an annex to the shareholder agreement, does that then bring the equity offer document into play, or where does the box of the actual shareholder agreement stop, where you have annexes that obviously are the equity offer document?
Yeah, so that's a really good point to make. So I mean, I can't speak for every agreement, obviously, and other agreements.
Only your own. Only your own.
Yeah, only my own. So the ones that I do refer to that equity offer document to identify the raise and identify the this is what we did on Leo crowdfunding, and this is how everybody knows it. But that's it. So that clause that I was referring to, the everything doesn't count, the entire agreement clause is what we call it, says, that document is not a contract. It's not part of the contractual terms. Basically, we're including it here, A, for reference, because it's always good to have to have it to hand, and B, so that you know what raise we're talking about. Because in particular, if you've got, repeat fundraisers or whatever it is, it's good just to make sure that everybody knows what one we mean. But no, it doesn't have the force of a contract, even though it's in there as an annex. Yeah, that's a great thing to clarify.
Yeah,
Perfect.
that's a
No,
really good
thank you for
thing.
that.
So we have articles, we have shareholder agreement, and we have annex, and the annex is, in a sense, background, but it isn't relevant to the contract. It's just
Right.
background.
Yeah, okay,
Yeah,
no,
that's
that's
it.
good. Okay, last question before we move to wrap up. Thankfully, this hasn't happened yet on our platform, but I know it has happened on other platforms, and undoubtedly it will happen on our platform at some point. A deal goes wrong, passive shareholders aren't particularly happy. They feel that either they agree to a bad shareholder agreement, but they're just unhappy. They maybe didn't get their ROI back. Maybe the deal goes horribly wrong. They get none of their initial capital to purchase shares back. Not acting on behalf of the fundraiser, just kind of put your independent hat on. What's the best way of that being addressed between the passive shareholders and the fundraiser?
Yeah, so that will depend on whether the fundraiser did anything wrong or naughty. I'm a parent, so I can use that word. Or if if it was just, unlucky is the wrong word, but it was just a bad deal. And in terms of mechanism, because what that opens up to you as a shareholder, if somebody has been naughty, is the threat of legal action. And I am not a I'm not a litigator. I'm at heart an agreeer rather than a fighter. But having that threat in the background is the answer to the question, so what, right? So I think it's really easy if a shareholder has some suspicion or some evidence that the fundraiser has been naughty, they have the ability to ask for a meeting, ask to look at the books, whatever it is, and it's backed by, without even really needing to say it, it's backed by an implied threat of, and if you don't, we'll sue you, because this will all come out in court. Now, for an individual investor, that might be too expensive, and they might have no intention of doing that. So I think the other thing that people can sort of start to look at is, are there ways that they can contact, are there, at your events or whatever, do investors get to know each other? Could they take some collective action in a particular deal? However it is that they've got to know each other, so that they can have a little bit more force and a little bit more voice. I won't go into any detail, but there are things that they can do as shareholders, even though they are passive shareholders in the articles. They don't have voting rights, but nevertheless, there are things that shareholders can start to require from the company, provided you can get to a critical mass. So a little bit of coordination, I think, would go a long way there.
Good. Okay. Right. We do have to move to wrap up here, but there's been a
So
couple of
just
questions.
to highlight a point of that, the FCA does encourage shareholders to know about each other. They think that's a benefit. At least that was how they behaved, or the FCA instructed another platform that they wanted it to be clear that shareholders should know about each other.
Yeah, that's a good point, and that's why we insist that it's the best practice, and what's required is that on Schedule 2 of the final signed shareholder agreement, it lists all the shareholders on that, so therefore everyone can see who their other shareholders are. So, okay, we definitely need to wrap up. However, a couple of questions come in. There's one relevant, so I think it's a yes/no answer, David. I hope. I've signed a shareholder agreement as an investor with a property development company. After querying one or two clauses and being satisfied with the company director's clarification via email, does this mean that any clarifications sent by emails are legally void and the company cannot be held account over these, if only the text of the shareholder agreement matters legally?
If there are clarifications, so they're explaining something which is written in legal language and is hard to understand, then you're fine. Because what they've told you is that's what that says in the contract. And provided they're telling the truth, that contract will therefore work. If what they're doing in what they've sent you is promising you something extra, then that's void.
Yeah. Okay. Perfect. Okay. So we need to move to wrap up here. Before I forget, other questions come in there. Yeah, the event for the at the PLMD offices is next Wednesday, the 9th. It was going to be the 3rd. There were train strikes. Then we're going to move to another date, more train strikes. So it's definitely Wednesday, the 9th. That's next Wednesday night is that event at the PLMD offices in Stratford. Next week, the topic of conversation is if house prices crash, what happens, who is impacted, and how landlords are safe. And I think we're going to turn this into an Ask John sort of elongated question. He hasn't had one for a couple of weeks, so we've been saving up his energy and his knowledge to get a good info dump on next week. So we'll make this an Ask John question, and so that's the topic next week, which will be very interesting, as you can imagine. There are a number of coming soon projects on the platform right now. We had hoped we'd had a couple view deal today, just hasn't quite happened. Final sign off, and while that is frustrating that it does slip a bit, it's down to the fact that the approval checks have to be done, the boxes have to be ticked. Our FCA principal Sharon obviously needs to be satisfied with the material statements and all the things that go into an approval of a document and a raise. So you can go on to both the event here, Stafford Gardens, and also Dunlickety House. You can actually leave an email address and an amount you may be interested in investing. So therefore, you're kind of on our list to be contacted whenever these move to view deal. And again, we've got the Becontree Tranche 2, and we've also got the Church Road Winterbourne, which is coming. I think next week, John, we're also going to have maybe a quick input from Ed Morgan. We're due to pay out probably today on his planning uplift. So the investors will get their money back. They can check their e-wallets, and we might give him a couple of minutes next week just to confirm payback, etc. So keep checking the platform. Some of these may go view deal tomorrow, maybe even this afternoon, but just keep checking those. So that is us for today. Thank you very, very much, David, for joining us. I hope you enjoyed your input. No doubt we'll get you back on again at some point to deep dive into some of these things.
Pleasure. Thanks for having me.
And David, if I send people your way, is there any particular way you want them to reach out to you? These would be people raising money for deals?
Yeah, through my through my work email. So david.willbe at Lewis Silkin, but you can find me on the website there.
Very good.
Yeah, and on LinkedIn as well. You have a LinkedIn profile, I think, there, so you can probably find it there.
Yeah,
there as well. So okay, so again, check out the recording. We'll be up in about half an hour's time, and other previous recordings at our YouTube channel, youtube.com/Leo Crowdfunding. And we'll see you all again next Thursday. All the best, everyone. Thank you. Bye-bye.
Thanks so much.